Hello, everyone. I know we have folks still joining us as we get started, but we will go ahead and get started. It's almost 1:02. So good afternoon, everyone, or good morning for those on the West Coast. I am Jenny Kean. I am RELA's Senior Executive Vice President for Member Services. Really excited to welcome you guys today to our session on legal liability for acts of violence in retail, understanding the risks. This is the 7th out of 8 of our series of our retail asset protection webinars. This is content, as you may know, that was originally developed for our AP conference that was scheduled for back in May, that unfortunately we weren't able to hold in person, but so now we're able to deliver this content virtually. It's all updated and ready to go for August 2020, and we're excited to be able to share it to perhaps a wider group than would have been able to join us at the conference. Before we get started, I just have a little housekeeping. The first is our antitrust statement. RELA, of course, operates by both the letter and the spirit of all antitrust laws. Our content has already been reviewed for that, and we've linked our full antitrust policy statement in the chat box. So take a look at it if you would like, and I'm sure we will be good today, but if anyone feels uncomfortable in any way, you can stop us and we'll get legal advice. I also wanted to just ping you, you may have seen it in the loop, but I do want you to save the date for our in-person asset protection conference. It will be hopefully our next time for our AP community to be together in person. All things go well, we hope. That'll be April 25th through 28th in Washington, D.C. And so please mark your calendars for that. And that's really it. I am going to turn it over to our moderator today. Really pleased to have with us today Walter Palmer, who is the Executive Vice President with CAP Index, who will be leading our panel today. Walter?
Thank you, Jenny. Thank you and welcome everyone. As Jenny said, we're going to be talking about acts of violence in the retail environment and the legal liability that can occur from those. I want to disclaim from the beginning, we're not going to be able to talk about every different type of violent act that occurs in our business. Unfortunately, we have to manage a broad spectrum of these. So today we're really going to confine the discussion largely to criminal acts by third parties. And to do that, we have a couple of people who agreed to join us who are real experts in this, who deal with this on the front lines. And as a result of their participation, I can pretty much guarantee you that you're going to enjoy the next hour at least as much as you can enjoy talking about really awful, tragic, sad events, because the root of these cases we'll talk about almost always start with something happening that none of us would wish to have happen anywhere in society, much less on one of our properties. But given the litigious nature of our society, once something like this does happen, people begin to ascertain who acted reasonably, who acted not reasonably, and start to proportion blame. And so we'll talk about the realities of that. So what I want to do is introduce our guest and then give a quick overview of the agenda. I'm just going to share my screen here. And we'll get right into it because I want to make sure we can cover a lot of ground today. So first of all, I want to introduce today's panelist, and I want to start with Nathan Brown. Nathan is the corporate counsel for the Kroger Company, where he manages all tort litigation for Kroger, as well as providing general legal counsel to its divisions, Smith's, King Soopers, Fry's, and Dillon's. Nathan currently assists Kroger's pandemic task force and provides legal support to Kroger's asset protection team. Prior to joining Kroger, Nathan was assistant general counsel at Walmart stores, working in its litigation and corporate practice groups. Nathan earned a Bachelor of Arts degree cum laude in political science from Brigham Young University. He also earned his Juris Doctorate, also cum laude, from the J. Reuben Clark Law School at Brigham Young University, where he was a member of the BYU Law Review. So Nathan, thank you for joining us. I'm sure with your responsibilities, especially with the pandemic task force, I'm sure you have nothing else on your agenda. So I appreciate you taking the time to share your insights today. Welcome.
Thank you.
Next up is Brian Turlock. Brian is a partner with Bindon, Summerall, and Ladner LLC in Atlanta, Georgia. His practice is devoted to litigation, where he focuses both on general liability and professional negligence actions. Before entering private practice in 2007, Mr. Turlock served on active duty as a judge advocate in the U.S. Marine Corps as a prosecutor. He remains in the reserves and is currently the Deputy Staff Judge Advocate for the 4th Marine Division. Mr. Trulock received his BA from Emory University in Atlanta and his JD from Washington University School of Law in St. Louis. And Brian, thank you for joining us as well. And congratulations on being in Georgia, which was recently had the honor of being named one of the top 10 judicial hellholes by the American Tort Reform Lawyers Association. So congratulations on that as well. But thank you for being with us.
You bet. It's a great place to practice.
So I think we're going to be talking about Georgia a little bit more as we get through the presentation. So briefly, the agenda here, real quickly, just going to set up the conversation around some of the legal issues at play. This is not intended to make anybody an attorney, but just set up some of the terms you may hear. And then we're going to get over to Brian to go through a case study of an actual case that he litigated on the defense side so that he can talk about some of the issues at play at jury trial and how they played with the jury and some lessons learned from that. And then Nathan also closely follows these types of cases and also can give us kind of a broad corporate perspective, having to manage these issues across a number of jurisdictions with different legal standards and such. He has a very broad view. And then finally, I'm going to reserve 5 minutes for talking about active shooter. And really the reason I put it on there is because it was going to come up in the Q&A anyhow. So I figured we'd just go ahead and talk about it because it's such a hot topic. So with that being said, I'm going to go right in and talk about negligent or inadequate security. First of all, it's typically the cases we're talking about are civil cases. There are fact patterns where you could have different types of administrative law, or even perhaps maybe a fact pattern where you could have a criminal case. I'm thinking in the UK under their Corporate Manslaughter Act, for instance. But typically we're talking about civil cases, and specifically we're talking about tort law. And we're talking about the division of tort law that is not intentional torts. These cases rarely are around an organization intentionally hoping harm comes to someone, but rather around negligence. And historically, generally, the courts have not held individuals or organizations responsible for the criminal acts of third parties. But back in the 1970s, I know, really started to become fairly prominent in the 80s. This idea of inadequate security based off the relationship you have with the person involved and what your duty is started to become a new part of the premises liability arena. And it's not disappeared over the course of the last 30 or 40 years, but last year it was really headline grabbing with some really big nuclear verdicts. There are a couple of retail cases in Georgia, for instance, with $43 million, $70 million jury verdicts that just really got a lot of attention. So not a brand new thing, but just something that's kind of raised its head again, I think, recently. So, okay, so general principles and terms, and you might use this sheet. I assume this will all be made available by RELA after the fact. This might be your guide. If you hear some terms come up in today's discussion and you want to learn more about it, this is kind of your guide to maybe go back and look at them. One of the things that comes up in our cases, not so much in retail, is duty. And is, do you have some type of duty to the person? And because in the retail setting, we're inviting people in for our benefit, typically this is really not at play. But Brian, you might talk about this a little bit in your case study, because it was a little bit at play in yours. But this idea that there has to be some type of relationship, and if you have a business invitee, you have a higher threshold of duty than you do if it's a trespasser, for instance. Voluntary assumption, I'll just mention real briefly there. Don't know if we'll talk about it today. You can assume a duty that isn't yours by law. So therefore, I'm thinking in retail, if there's like an area that's maybe not your parking lot, it's not you don't own it, you don't control it, but you start encouraging your shoppers to park there when it's busy. Maybe you start collecting carts from there. You might assume a duty for an area that wasn't yours otherwise. So that comes up occasionally. Breach is just the idea that you did not act reasonably. And the difficulty with this is that there are no bright line rules. The courts have never said, if your risk is this, you should put this many cameras in, or you should have this. And so this is always something that's going to play out in a jury trial as being able to mount a case that says we acted intentionally and reasonably. Proximate cause means a couple of different things in different jurisdictions. What you're going to hear most often around cause is the idea of foreseeability. and you'll hear that today for certain, which is, did I have some warning that there was a specific risk of this type of incident occurring? And the historical standard, and still the standard in many places, is called prior similar. Were there prior incidents that were similar in nature to the event that occurred that we're litigating? And even there's a lot of questions that have to be answered. How far back can you go? How similar does it have to be? Would a motor vehicle break-in be a predictor of carjacking, for instance? So prior similar, still there's lots of questions of fact that have to be answered. And then in the late 90s, early 2000s, you had some jurisdictions moving to totality of circumstances, which is broader. And then more recently in South Carolina, a few years ago, they came in with this balancing test. Again, I think prior similar is what you're going to hear most today. But again, if you want to go back and learn more about this, these are the terms that you're going to hear. And then you're certainly going to hear about damages today. Most people understand compensatory damages are under the auspices of making somebody who's been aggrieved, make them whole. And that happens in financial terms. Punitive damages are those damages that are intended to punish the wrongful party. And then you're going to hear about apportionment today. And I'll leave that for the later discussion. So these are just some of the terms that you may hear in today's discussion, or that you're going to hear in these conversations in general. So this can be kind of your cheat sheet, if you will. So with that, I want to come back to Brian. So Brian has been out there litigating these types of cases, and is going to share with us a case study today that has a tremendous amount of insight for us as practitioners, I think, as well. So Brian, with that, I'm going to turn it over to you and let you walk through this, and I'll try to keep up with your slides.
Sure. Thank you, Walter. So this is a case, and if any of you are familiar with it, that we tried last March here in Atlanta and Fulton County. It has a fairly interesting fact pattern. It involved a plaintiff. His name was James Carmichael. I don't mind sharing that. And Mr. Carmichael was an individual who was in the business of selling used electronics out of the trunk of his car. And he was a resident of Alabama. He had been in Atlanta for a couple of days buying and selling used electronics when he met an individual, a third party by the name of Frankie Gray. Mr. Gray knew that Mr. Carmichael liked to sell these used electronics, and said, hey, can I get your phone number? Maybe one day we can meet and I might buy something from you. So sure enough, in December 2012, Mr. Carmichael's on Interstate 20 on his way home. He's about to leave the Atlanta city limits, and he gets a call from Mr. Gray out of the blue saying, hey, I'm interested in buying an iPad from you to give to my daughter for Christmas. And Mr. Carmichael says, great, that's wonderful. Why don't you meet me in this retail parking lot in about 20 minutes and I'll sell it to you. So Mr. Carmichael turns around, gets off the highway, goes to the parking lot. Mr. Gray subsequently shows up, and all of this is captured on our surveillance camera. Mr. Gray gets in the car with Mr. Carmichael. They engage in a discussion over the price of this iPad. For unknown reasons, they are unable to reach an agreement as to the price. You can see Mr. Gray get out of the car, and not a second later, a third unidentified individual gets in the car with a gun, points it at Mr. Carmichael, starts demanding his money and his electronics. And Mr. Carmichael then gets the bright idea to reach behind the passenger seat, where he gets his own pistol, shoots twice at the third party in his car. His gun jams, and the unidentified assailant shoots Mr. Carmichael about 6 times at point blank range with a .45 caliber pistol. Mr. Carmichael amazingly survives, manages to get out of the car, walk into the retail establishment where they call 911, and he spends the next several months in the hospital, recovers from his injuries, amazingly only has some minor nerve damage to his left arm as a permanent injury. And then, of course, he turns around and sues, claiming that our security was inadequate, and that if only we had had a security guard in place, this tragic incident would not have occurred. So what did the plaintiff have to prove? Basically, under Georgia law, which is similar to a lot of different states, they had to show that This shooting in the parking lot was reasonably foreseeable. And under Georgia law, reasonable foreseeability is determined if there are substantially similar previous criminal acts at our location. So the plaintiff had to show that there were substantially similar criminal acts on or about our premises. That gave us notice, and we had to take reasonable measures to guard against those. So they argued that we had notice, that this was preventable, and that we needed a security guard in order to deter the shooting. So our defense was that we didn't have notice. We had had a lot of sort of petty theft on our premises, the typical sort of shoplifting things that occurred inside the store. We had had 2 previous armed robberies inside the store. We argued that those were not substantially similar because they occurred inside during the day, and that they were criminal acts against the store and not against a customer. And then we had also had 1 purse snatching that had occurred outside the store in broad daylight that did not involve a weapon. And we also argued that there was no way that the retailer could have had superior knowledge of this criminal act because Mr. Carmichael was targeted. We said that this was an obvious conspiracy between Mr. Gray, who we had deposed, and this unidentified third party, and that there was no way that the retailer could have had superior knowledge of a criminal conspiracy between Mr. Gray and this third party to target and rob Mr. Carmichael. So those were our essential defenses. The jury, of course, disagreed, and they awarded a verdict in favor of Mr. Carmichael and awarded him in excess of $40 million. This was a purely compensatory award. There were no punitive damages awarded, but we believe it was definitely sort of a punitive award disguised as a compensatory award in order to punish the retailer. So how did the plaintiff succeed, and what were some of the lessons learned as we developed the case in discovery and went through trial? Number one, the plaintiff's counsel in this case was a gentleman named Pete Law. He has certainly developed a niche in this type of litigation. He's extraordinarily effective and does a very good job working the case up in discovery, which a lot of plaintiff's lawyers simply do not do. He found former employees, he subpoenaed them, he took their depositions, and a lot of them basically said that they had requested security at the store location and that their requests for security were ignored. Now, they frequently testified that they felt the store location was unsafe. Now, whether that's relevant or not, I think is a matter of debate, but that certainly allowed the jury to develop some level of animosity towards the retailer because they had store employees who said they felt unsafe, even though that didn't really match the actual criminal activity at the store location. And no security guard was ever brought in to alleviate their own personal concerns about safety. And then there was also a significant gap, and this was sort of learned as discovery went on, and certainly in the litigation, which the plaintiffs were able to exploit. There was a real gap in the difference between loss prevention and store operations. And this was really critical, I think, to the plaintiff's success. There were, Walter, you can move on to the next slide, please. So the store, there was a gap between who was responsible for deciding whether security guards were necessary and deciding when and how they were going to be placed in various retail locations. The store managers said that they had the authority to request security guards, and the loss prevention folks said that once a request came in, they would sort of manage the contract and place security guards in various store locations. But a lot of the discussion around security guards dealt with loss prevention and shrinkage, and almost none of it dealt with security of employees or customers. And there was a real gap between the operations folks and the loss prevention folks about who was responsible for sort of monitoring and taking care of the safety of employees and customers versus protecting the product in the store location. So while there was a process in place for monitoring shrinkage and shoplifting and those types of things, and then making a decision about whether a security guard might be necessary to deter those types of activities, there was very little discussion about when and how you might place a security guard in order to protect employees and how you might protect customers. And that was really a gap that was exploited effectively by Mr. Law during trial. And it, I think, caused a significant amount of anger to develop in the jury towards the retailer, primarily because they view security guards as a very inexpensive solution to crime. Now, whether or not they're actually effective, Walter can probably speak to that, and other folks. There's lots of research that says they may not be quite as effective as juries believe they are, but a jury is going to think that a $10 to $15 an hour security guard is a cheap and inexpensive solution to a problem for a company that is a Fortune 500 company making millions or billions of dollars a year. You have to be able to explain to a jury the reason that you decided not to place a security guard. So truly one of the lessons learned from this litigation is that a retailer, especially a very large retailer, has to have objective measures in place for deciding when and how they're going to place security guards across the enterprise, and be able to explain, have somebody within the organization who can say, look, you know, this crime occurred at this location. It did not have a security guard, but these are the metrics that we use for deciding when and how a security guard needs to be placed. And we monitor the criminal activity at the store, both our own internal reports and criminal activity in the area. And those are the objective metrics we use to say, when it hits this level, we're going to put a security guard in there. Or if it doesn't, we're not going to put one in there. But in our particular case, there was a gap in that particular department, and no one was really able to explain effectively when and how security guards were placed. It was relatively haphazard in terms of deciding which stores received guards and which stores did not. And this case was complicated by the fact that the store in question had a security guard at one point, but it was taken away, and nobody could explain the rationale behind taking the security guard away before Mr. Carmichael was shot in our parking lot. So if you're talking about security guards specifically, there are, of course, many considerations to take into account when deciding whether to place them, whether you want to have armed or unarmed security guards. Certainly armed security guards come with their own issues. They have to be have very specific post orders as to when and how they are able to use their firearm. Certainly that could result in other issues if somebody uses a firearm and harms another customer or another employee while trying to intervene in a criminal act. So that goes to having very specific post orders and rules of engagement for your security guards. And then again, whatever decision you make, you have to make sure that it's documented and backed by objective evidence. You can't just decide to place security guards based on a store manager's feeling or a loss prevention manager's feeling that a store might be dangerous, or a feeling that it's safe. You have to have some objective measurements to decide how these decisions are made. And then also concerns about store safety. In our particular case, store employees testified under oath that they had expressed concerns about store safety to the store manager. Those were not written anywhere, they weren't documented anywhere, and it's not clear that those concerns or complaints went beyond the store manager to anyone higher in the bureaucracy. So again, that was a reason that the jury found to harbor significant anger at the retailer for its apparent failure to put in place an inexpensive solution that they believed might have prevented this particular criminal act.
Hey, Brian, I just wanted to make one comment to emphasize it, because when you read the transcript of your case and the other case, you know, and I know your case specifically, you touched on, I just want to reinforce, I think a lot of organizations think not having stuff documented is a good defense. But in this case, nobody could ever answer where the complaints went. Did they get the complaints? Did they make a decision? What was their rationale for a decision? It was just everything disappeared into the ether. And it looked really damning to the jury, just around competence even. And so I think a lot of people consciously think, oh, if I don't document anything, I'm in a better position. But in this case, it was like the complaints from the store were not even acknowledged because nobody could answer who got them, who acted on it, was there a discussion? So there was no way to say we were reasonable in our decision. I mean, that was the way I read it when you read through the transcript. It's really prejudicial, I think.
No, you're absolutely right. And it's not like the plaintiff found one former aggrieved employee where we could cross-examine them and say, well, you know, you're here testifying that you expressed concerns about the store because you were fired for stealing. There were several employees, all of whom had consistent testimony about their feelings about the store, but it didn't go anywhere. And that was a real problem. And like you said, documentation is not bad. If you have some way to explain the reasons that you make a decision, that can go a long way towards mitigating some of the anger that a jury may develop through the course of litigation. In addition to security guards, a lot of retailers have not only their physical structure, but parking lots to worry about. One issue with security guards is deciding where are your security guards going to patrol. Are they going to stay inside the store and focus on customers inside the store and product that's inside the store, or are they going to be responsible for also patrolling the exterior parking lot? In this particular case, Mr. Carmichael was engaged in a private business transaction in our parking lot. He testified that he viewed the parking lot and our retailer as a safe space to engage in private businesses. One idea to consider, and this is again something that may be cost prohibitive depending on how large your organization is and how many parking lots you have to cover, but putting signs up that say that parking is for customers only and that private business transactions are prohibited. It's something that might allow a jury to believe that an individual engaged in a private business transaction is a trespasser and not a licensee or an invitee on your property, which lowers the duty that the retailer owes to that individual to protect them from third-party criminal activity. Lighting is always a huge issue in these security cases, whether you have documented maintenance of the lighting in the parking lot, whether there's adequate lighting coverage in the parking lot, dark areas where criminals might be able to hide. Those are always huge issues in negligent security cases. So you have to have documentation that your lighting and your security in the parking lot is adequate.
Brian, I just make one comment on that as well, because in lighting, I think in both cases, yours and the one down the road, I can't remember which one hadn't been relamped on schedule, but you know, everybody said, oh, the parking lot's dark. And I think as your case, you made a very effective argument that the lighting had nothing to do with the case in question because it actually happened very close to the store. It was actually fairly well lit. But again, it just came across as prejudicial that the company hadn't done the basics, right? They hadn't relamped on schedule. The lighting was out. And so even though there was nothing, it really had very little to do with the actual incident. It just looked sloppy, like we don't care. I mean, and again, these are things that's very hard to predict how a jury might have reacted in a different circumstance, but it seemed to come across as like, you didn't even bother to update the lighting when you said you would. And we're going to hold that against you, whether it had anything to do with whether this shooting occurred or not. That was the way I read it.
No, you're absolutely right. In our case, the lighting didn't make any difference. The incident occurred, and not to mention the presence of a security guard wouldn't have made a difference because this happened right next to the entrance to the store where the overhead lighting was perfectly adequate. That's the reason you could see everything on the surveillance cameras, because the lighting was excellent. So lighting didn't make a difference, but there was some lighting on the exterior of the parking lot that had not been maintained on schedule. And again, it's just like you said, something that the jury can latch onto and say, hey, here's this large corporation that can't take the time or effort to change a light bulb, you know, put in a $1 light bulb, which they're going to think that gives a criminal someplace to hide and plan a criminal attack. The last point I want to touch on very briefly is apportionment. I don't know how this works nationally, but certainly in Georgia, we have what's called an apportionment statute, which allows non-party criminal actors to be placed on a verdict form. It can reduce jury verdicts in some circumstances. So in our particular case, we had both Mr. Gray and the non-party shooter, third-party shooter on the verdict form. And basically how it works is if a jury awards $100,000, they can apportion any amount of fault to the non-party criminal actors. So let's say they apportion 50% of the fault to the criminal actors, the verdict just gets reduced by 50%. So a $100,000 verdict goes down to $50,000. It sounds great in theory. It doesn't always work very well. For instance, in our particular case, despite the fact that there was evidence that the John Doe shooter intentionally shot Mr. Carmichael 6 times with a .45 caliber pistol, the jury, in its infinite wisdom, apportioned 0% of the fault to both the shooter and Frankie Gray, who almost certainly lured him to the parking lot. It's my opinion that apportionment can work, but it's only going to work and be a successful strategy when the store has a sound methodology for determining its security precautions. If a jury has any reason to get angry and sort of incorporate a punitive damages award into a compensatory damages award, they're not going to pay any attention to the apportionment part of the jury instructions, and they're not going to apportion fault, mainly because I think they know and understand that all that's going to do is reduce the plaintiff's recovery. They'll get instructed on that. They'll understand that, hey, if we award $1 million and apportion some of this to the criminal actors, even though they're at fault, all we're doing is taking away from the award that the plaintiff's going to get. So it sounds great. It's a good law in theory, but it's difficult to make it work in practice. So a lot of these are issues that are on appeal. Right now in our particular case, and I know Nathan is aware of other appellate activity in other cases in Georgia, but a lot of these are issues that are circulating at the appellate level right now.
Thank you, Brian. A great start to the conversation. Nathan, I know you not only follow this in Georgia but across the country, but I know you followed these particular retail cases fairly quickly. Any things you would add here or other lessons learned, I think, from these 2 particular cases, or just in general?
No, I think there are some lessons, and I think the first lesson is part of my topic for the first section of my slide, and that is that jurisdiction and venue really, really matter. Brian just talked about apportionment. The black letter law really talks about how, it should be apportioned fairly across the various actors. I think common sense would dictate to anybody that a criminal actor who commits a crime against somebody is, shares a lion's share of the fault for that. And in his particular case, they gave absolutely 0, which means that the jurisdiction, the jurors there probably didn't do their job, or at least weren't doing it as they should. And so we've seen that across the country. Georgia is unfortunate because they do get instructed that the amount of the apportionment will reflect on the recovery of the plaintiff. In other jurisdictions, they apportion it, but they don't really mention the fact that, the more you apportion it, the more the plaintiff will not receive. Smart jurors were going to figure that out anyway, but it's nice not to have that explicitly mentioned by the judge. So along with apportionment, there's lots of issues with jurisdiction. And one case that has very, very similar fact patterns, let's say in Atlanta, in places like Wichita, Kansas, or Salt Lake City, Utah, will probably result in summary judgment because they don't even meet the basic legal functions. So some of the things to think about when you have the various stores in various places is the jurisdictions in which you lie. The black letter law elements, the ones that Brian mentioned, we talked about foreseeability, we talked about reasonable conduct. Those are pretty standard across just about every jurisdiction in this country. It's how that's applied to the facts of the case that really matters. And part of that is the plaintiff themselves. So if you have a very appealing plaintiff, Kroger had a pretty devastating verdict in Georgia just about the same time that Brian's case was going to. And one of the big challenges there was that the plaintiff was an extremely likable individual. He's a former veteran, not dishonorably discharged, but honorably discharged. He had no criminal record. He was there to use the store services. He was a member of the community that they wanted to protect. And he also didn't bring any problems with him. A lot of these security cases that I've covered over the years have been instances in which maybe somebody brought the conflict with them. In other words, they brought a personal beef onto the lot. Maybe it was gang activity. Maybe it was a personal kind of a marital dispute, a lover dispute. And so it was not connected at all to the store or even in shopping at the store. It was more of a personal beef that then spread to a property that the store controlled. And in this case, he didn't have that. So your plaintiff, especially if that plaintiff is very, very appealing, and particularly a member of the community in which that crime occurred, there's a lot of incentive for a jury to take care of that person, to take care of their neighbor, so to speak. So that really, really matters in venue. The court really matters. I have a preference for federal court if you can get there. The challenge in most of these security cases is that they will sue not only the retailer in this case, but also the criminal actors, and that will defeat diversity of jurisdiction. So, to get into federal court, as a basic primary, you have to have an amount of controversy over 75,000, which in these cases is usually met quite easily. And then you have to have diversity of parties. So that means that both sides can't be the member of the state in question. So, for example, Kroger is an Ohio corporation, so their citizenship is Ohio. If they are sued by somebody in Atlanta, we can move it to federal court unless they also sue a member of, another citizen of Atlanta or Georgia, as it were. And so that makes a big difference if you can get into a different court. Just because I found that appointed judges are much more likely to follow the law and grant summary judgment than elected officials, elected judges, for various reasons. The other thing is that I would talk about as jurisdictions is if you have members of the community who are suffering at the same kind of level. So what I found is that a lot of these happen in kind of high crime neighborhoods where a lot of the members of the community are already being suffering in these kinds of situations. And so if they have an opportunity to recompense one of their own for suffering from some of these problems, they're going to do that. And they're not going to have any kind of sympathy for the retailer. And they're also not, and that's pretty evident in the apportionment, because I think common sense dictates that there's certainly more than 0% apportionment. In the case that Kroger handled, they gave 7.5% essentially to each of the two carjackers that shot this individual, and the rest of it, essentially 85%, was apportioned to Kroger. So that's a real challenge, is figuring that out. So jurisdiction is really, really important. The other topic that I think is important is you got to know the appellate landscape. And what that means is we had a bad case years and years ago in Mississippi, and it was a purse snatching case. And it was an elderly lady who did not let go of her purse, and so she was dragged some distance and lost vision in her eye. So again, very, very sympathetic plaintiff. And they awarded her, the jury awarded her millions of dollars. That went up on appeal. And essentially we won at the Supreme Court level. And they looked at it from a factual standpoint and a legal standpoint and said that this act was not foreseeable, that of the tens of thousands of shoppers we'd had in that particular store over the last several years, not one of them had this happen to them, or a similar thing happened to them, a violent criminal act happened to them, and therefore it was not foreseeable and we owed no duty, and that our precautions were reasonable. So, even if you lose at that basic level, and maybe you have a very sympathetic jury, if you are in a venue or a state that has a kind of a more reasonable Supreme Court or a reasonable appellate court, and that is really willing to look at the law instead of the sympathy factor, you can have a positive outcome. So as you talk to your lawyers, as you try and work up a case for defense, make sure that they preserve all the objections that might be able to be brought up on appeal. Because the sympathy factor is very, very potent at the trial court level, and it fades quite a bit at the appellate level, where they are just looking at the briefs and maybe oral argument. And so they're applying essentially the facts to the law, and they're not worried about rewarding somebody or that kind of thing. So that goes to the concept of venue also, is know the appellate landscape. And now some practical advice as I've handled these across the country. What I've found really, really works is that you must use a consistent approach. So remember, the two most important elements, I think, and Walter touched on this at the beginning of the presentation, are foreseeability and reasonableness. And so whatever approach you take to security, it has to be based on those two elements. So if you can show that something is not foreseeable, so if you have data to back up the fact that this particular location, this particular store, it just doesn't have a problem with violent crime, and that if something does happen out of the blue, that it clearly wasn't foreseeable, and you have the data to back that up, you're in a much better position. The reasonable conduct is also important, because then it shows that even if you didn't have security guards at this particular location, you've run the numbers, that you have the data, and that data tells you that it's a very, very safe place, that it's not foreseeable that something bad like this would happen, and therefore that your conduct was reasonable. Also going to that consistent approach, I think it's really important to use really good data. And by that, I mean, maybe use a third party like Cap Index. I know that our organization uses Cap Index to really figure out what's the nature of the surrounding neighborhood, what kind of crimes have occurred there. We also use some internal data that, our own records about what's happening in those places. And then we could set up a consistent scheme of, if there's certain elements are met, then this level of security is required. Maybe it's an armed security guard. Maybe it's an unarmed security guard. Maybe there's no security guard. Maybe given the nature of those crimes, that we have a security guard in the parking lot, but not inside, because that's not where the action's happening, so to speak. Or maybe we have them inside and not outside. But it's really about being consistent and being smart about the data that you get, and then what you do with that data. Because the program that you create, the elements that you look at are only as good as the data that you get. And last to that point, it is far more damaging to come up with a good program and then not follow the program than to have no program at all. Because it's been my experience that nothing angers jurors more than knowing that the organization had a good program, that they expended resources, and then just failed to do it. In some ways, that we are taking a duty upon ourselves when we create those programs. The point is to deter the criminal activity, and then also provide us with a good defense. And if we don't do what we've kind of promised to do, or that we've committed to do, that can be more damaging in front of the jury than just having no program at all. The other point I'd like to make is managing to the data and not the dollars. Nothing's more damaging at trial than to hear of something that, oh yeah, we got rid of those security guards, or we didn't put the lights in because we didn't have the money in our budget. Especially if that money is relatively modest. I think Brian touched on the fact that the jury didn't think that an unarmed security guard would be that expensive. Light bulbs are fairly cheap. So you need to really manage to the data, not the dollars. Of course, it's obvious that resources aren't unlimited. Sometimes there are budget cuts, but you really need to manage that process with the data instead of the budget. And for example, if you have budget cuts in your security budget, then you would go to the data and say, well, we can take away certain things from this particular location because they're actually doing better. The numbers tell us that we actually need less there than in this particular location. And that way you could reallocate your resources to where it's really needed, and show that you made that decision not based on, oh, I needed to save money, but, oh, I can reallocate this resource from a place that's doing much better and is much safer than it used to be to an area that is not so safe. Going further on managing to the data, the key to any kind of trial, I think, is showing that changes you make in security are driven by reasonable acts. And so if you are removing data and you're not doing lighting, the point is to make sure that you have a reasonable explanation that's not just, oh, I needed to save money. It might be that I needed to reallocate certain resources to a store that needed it more imperatively than this store, and that kind of thing. And then the final point that I'd like to make is don't confuse the violent acts with property crimes. And so this is what sometimes I think in the loss prevention world, we get confused with, crimes like shoplifting. Well, that's crime. And then we have some shootings and robberies and rapes and those kinds of things that are quite violent. When most courts are looking at this, and most juries are looking at this, the standard is, what is the security for these violent crimes? So if you have a very, very safe store that has absolutely no violent crime, no history of violent crime, the neighborhood is extremely safe, But say there's a really bad shoplifting problem. That's a different kind of metric that I would use, and it would be completely different than the metric that I would use for security, as far as keeping people safe. So it's sometimes easy to blend the two, but I think it's really important to delineate what am I really doing here? Am I trying to create a program that is keeping people safe, or am I trying to create a program that is protecting the assets of the company? Shrink, that kind of thing. Both are important, but sometimes I think if we concentrate too much on just the shrink part of it, we don't necessarily take into account the security of it. And the security at the end of the day is what matters to the people who are shot and killed and raped and those kinds of things. So I think it's important that we don't confuse those acts.
And
so
Nathan,
those are kind of the things I've noticed. Yeah.
Yeah, I think actually you're seeing the plaintiff's attorneys play that up a little bit. Brian mentioned the fact that there was training in place for loss prevention policies and what you do with a shoplifter, but not about crime in the parking lot. And I think you're seeing some of the plaintiff's attorneys say, hey, the company cares a lot about their shrinkage because that affects their profitability, but they don't care about their customer safety. I mean, I think they're actually using that almost against the retailer as leverage.
Absolutely, and I think some of the techniques and programs you institute for shrink are completely different than what you would do for security. So if you think of and security by preventing violent acts. So if you think of what you might do for shrink, you might put in some sort of secondary barriers where I know that in some stores we've had in some areas where there's a lot of shrink, we put high theft items in an area that they have to go through 2 points of sale to get out of the store. And can't just kind of walk out the door. Well, that's great about protecting the razors and the Tide and the baby formula, but that's really not going to prevent anybody from shooting somebody. Not important, but it just doesn't have any kind of relation to that. So you really have to plan your security designs, your protection designs around what the threat is. And so if you have a store that maybe has a shrink problem, but certainly not a violent criminal problem, what you do with that store would be completely different than one that maybe doesn't have much of a shrink problem, but might be in a neighborhood with a lot of violent crime.
Excellent, thank you. I want to touch on active shooter for just a second and get you guys to weigh in. I will take the lead on this, and then we'll come back to some Q&A that's coming in around the issues that we've been talking about. So just real quickly on an active shooter, I just I'm gonna make some statements and then see if you guys are seeing any differently. Every time one of these horrific events occurs, there's obviously a tremendous amount of press, and you started to see more and more people starting to act like there's some kind of responsibility on the part of retailers in particular. And here's a quote from a plaintiff's attorney right after one of last year's really horrific ones, and they just said mass shootings have become so common in the U.S. they are foreseeable in any location that attracts mass gatherings of people. And so the question becomes, number one, what's a mass gathering? And number two, that would be such a huge, forget about the practicality for a second. We'll talk about that, I guess. But because that wouldn't just be a Kroger, that wouldn't just be, a Walmart, a Home Depot, whatever. It would be anywhere there's gatherings of people. And in fact, we know that active shooters occur in synagogues and in churches and in office buildings and in DC, depots. But this would be, I want to ask the two legal people here, this would be a huge change in the whole concept of foreseeable. Is that, and this is why these claims don't go anywhere so far, but people are starting to say this. Brian, you're shaking your head. I mean, is this the right level of foreseeability around something that the criminology community says is not predictable?
Well, yeah, and I'm a defense lawyer, so I'll tell you that I think that statement is an objective misstatement of the law. And the way at least Georgia courts look at these things is whether a criminal act is foreseeable at a particular location. So it's not, you can't look at every Walmart across the country or every CVS across the country or every mass shooting across the country and say, well, mass shootings happen and therefore they're foreseeable. And the second point is, in all of these cases, it's superior knowledge of the risk. So does CVS or Kroger or Target have superior knowledge of the risk of criminal activity? And if the plaintiff's bar wants to take the position that mass shootings are so common that they're foreseeable, well, that means that the general public is aware of the risk equally to the retail establishment. And if everybody has equal knowledge of the risk, then there's no liability. So I don't think that particular line of reasoning is going anywhere. And I also think it's an objective misstatement of the law, at least as it currently exists in Georgia.
Right. Nathan, any different take on the issue?
I agree with Brian completely. In fact, most of the cases that I've seen, the geographic area that they're talking about is usually less than a mile. And that makes a lot of sense. If you've ever been in a big city, you can go 3 blocks and go from a place where you're perfectly secure to a place where you might be a little bit nervous. And so it's very, very granular about how far. And I know the plaintiff's bar tries to expand that as far as they can. And sometimes they're successful in getting it a few more miles than we would like them to do, but certainly not nationwide or countrywide or store-wide. That I agree is a complete misstatement of what the current situation is.
Yeah, I mean, the implication of this would be, if you think about the Macy's shooting in Washington State a few years ago, I mean, a shooting where the person had absolutely no relationship to anyone in the store that we know of. It lasted 51 seconds, no forewarning whatsoever, and in a super low crime community. This standard would say I have to have security guards there, which is, it is not even probably feasible. So from a resourcing perspective, so. Big change.
I'll just point out something. We have an active case, so no, I won't go into too many details. But in that case, the shooter was motivated by race, and his first point of attack was a church, but the church was locked, and so he went to the next place that was open, and that was the Kroger store. So not only was it not foreseeable by us, it wasn't even foreseeable by the perpetrator. It was so remote in his thoughts that his point of attack was a place that wasn't a Kroger store, and then it became just kind of a crime of, well, I'll just go to the where I'm at. I'll just go across the street, and so it wasn't even foreseeable to him until about 5 minutes before. So I think that's why most of these are probably not going to succeed unless there is a kind of a change in the law. The concern I have is that, there's the old adage that bad facts make bad laws, and maybe some of these are so horrific. We saw the Las Vegas shooting, and then I think it was MGM settled out for hundreds of millions of dollars. Not because I think that the liability facts for them were bad, but because just the situation was so horrific that, you don't necessarily want to test that in front of a jury.
Yeah. I think it's really important to the practitioners out there. Anytime you hear anybody who, for their own motivation, is advocating that the OSHA general duty clause or anything else covers active shooters, I would push back on that right now, because I don't want to see us go down a slippery slope that goes to just unreasonable. I love it wasn't even foreseeable to him, and yet somehow it's supposed to be foreseeable to you. I want to go, we've got about 6 minutes left on the clock. I want to go to a couple of questions that have come in, and one is back to these parking lot cases, back to a couple of things you guys talked about. And that is guards inside versus outside. I think, Brian, maybe you just touched on that a little bit. I think, Nathan, I think we heard a little bit about where your issue is. Because I think there are some cases where there was a guard, but the guard wasn't where the plaintiff said they should be, and so, this whole, even if you invest in a guard, Brian, you mentioned post orders. Nathan, again, you talked about shrink versus outside. Just any commentary about what you guys are seeing around, even when there is a guard, it's still not enough sometimes.
I'll weigh in on that. I agree with that, because I think in most of the cases that I have faced in the last 10 years, we've had a guard. They just either weren't effective enough to deter them. And so then the argument became, well, you should have had an armed guard. Maybe a gun would have made a difference, which is doubtful. Or it was a guard that maybe had post orders to be stationed at the front of the store, but then every 45 minutes or so make a circuit of the parking lot. But of course, those crimes happen between those circuits. And so it really is, again, going back to the data, where do you see these crimes happening? If it's parking lot crime and it's really a security crime, then maybe you should have someone stationed either at the entrance looking out, or maybe, in some stores, we've even had, golf cart security officers, almost like at a mall, where their job is basically to circle the lot. They might be stationed at the front, but they might circle more frequently than once an hour. So that is a challenge. And again, it goes down to venue, because I would say that what more can you do than have a guard on duty that's doing rounds and trying to protect the public? Unless you want to make that an armed camp, where everybody who's coming in has to pass through a security gate with a armed guard at the checkpoint. It's pretty hard to defend against that.
Yeah, and that's where you kind of get, I was going to say that on the active shooter, that's kind of where you get, okay, even if I had to have a guard, how many would I have to prevent a shooter who's determined? I mean, if you think about the Dayton shooter, I mean, he was engaged by police officers in 24 seconds and still killed 9 people. So, and I think there were 5 or 6 police officers that responded in that time. So the question even becomes, what would the penetration level have to be to create an environment where no crime could occur? And again, the courts have never asked us to be the guarantees of security. So it's kind of a mixed up world.
And the other thing I would say is that I've had at least 2 lawsuits in the last 10 years where we were sued by the security guard because they were injured in a crime, saying that we provided the security guard with inadequate security. So, you just have to use the data and do the best you can and try to be reasonable, knowing that it's not going to ensure a positive outcome, but you can kind of stack the deck a little bit more in your favor.
Brian, any final comments on inside, outside, guarding allocation in general, just based off of what you're saying?
No, I think that Nathan hit the nail on the head. It's, I think, has to be a data-driven decision about where you put them. And it's interesting that Nathan mentioned the lawsuits by security guards. I've actually had my first lawsuit by a security guard against a apartment complex. So those are, I didn't know that those happened, but apparently now even the security guards are turning around and suing for injuries they sustain in the line of duty.
Right. Well, we're coming up right on time. I would I've got a couple more questions in here I'm trying to get to. Cameras in the store, but not in the parking lot. Again, I think this is probably pretty common in retail. And again, I think you're getting some plaintiffs' attorneys, using this in their favor, saying, "Oh, you put cameras all over the inside, but you didn't put them in the parking lot." Any comments about how you guys are dealing with those issues? Nathan, maybe go to you first.
I think from us, our perspective is that if it's our parking lot, we put cameras in it. And if we're going to put cameras in it, we're going to say that we put cameras in it. The challenge comes sometimes, we are tenants in a kind of a shopping strip mall, and the landlord is the one who's in charge of the cameras and the lighting and everything else. And so sometimes we can shift some legal liability to those parties, but it depends on what they want to do with their risk analysis as to whether there'll be cameras. Now the extent of the cameras can vary from just a couple on the outside of the building that kind of point out into the parking lot to various towers at all angles, and so that's kind of a really more granular issue as to how in depth do you want the coverage, and probably a question for another day.
Yeah, Brian, just I think Nathan kind of touched on about shifting liability. The question is really about using third party. If you have clear post orders, can that help you shift liability to the guard if they operate outside their directives? I think the answer to that is yes, in theory it can, but yet it seems like a lot of times post orders are very murky in the retail security guard usage.
I think that's true, but I think the answer to the question is yes. If you have well-defined post orders and you have a security guard, either your own employee or hired through a third party who acts outside those, or a third party security guard that acts outside those post orders, and an injury results because of that, you can absolutely, I think, as a legal strategy, try to shift some of the liability to that third party entity that employs the security guard or the security guard himself.
Yeah, so I think I'll leave a closing thought, which is, it's always dicey to try to predict what a jury would or wouldn't have decided in a different circumstance. But I think the ability to tell a story that says you take these issues seriously, you take care of the basics, and you have a decision-making process that you can explain, doesn't mean that you're gonna get it right every time, but at least it's less prejudicial to the jury in the absence of those factors. So with that, we have some unanswered questions. We'll try to do that through RELA as a follow-up. And then I'll just remind people our Orcas Enough is scheduled for September 10th, and registration's available. There it is on the screen. So Nathan, Brian, thank you so much for your willingness to share your expertise and your insights. Very appreciated by the community as a whole. Thank you so much.
Thank you.
Okay, everybody have a great day.